All right, we're going to talk about the single member LLC versus the sole proprietorship, pros, cons, and frequently asked questions. Hello, I am David Holt, a healthcare attorney at Holt Law, the law firm built for healthcare businesses. Been doing this for over 10 years. Today, we're going to address a fundamental question that I get all the time. It's what is the difference between a sole proprietorship, a limited liability company, and how do you choose which one is better for your healthcare business or practice? So let's start with the limited liability company or LLC. In the healthcare context, an LLC is a business structure you file with your state using a chosen name that provides limited liability. This means that the company is liable for its debts and obligations, but your personal assets are generally protected. Now, let's contrast that with the sole proprietorship. This is the simplest business structure where you operate under your own name without a formal registration. And imagine you're a therapist offering consultation services or a nurse providing home care. If you haven't formed an LLC or corporation, you're likely operating as a sole proprietor. So, what's the key difference? In a sole proprietorship, you are personally liable for all business debts and obligations. This means your personal assets, like your home or savings, any cash that you have, any liquidity could be at risk if you're sued or if the business incurs debt. With an LLC, on the other hand, your personal assets are typically shielded. From a tax standpoint, both sole proprietorships and single member LLCs are generally treated the same. However, an LLC can elect to be taxed as an S Corp. For example, Holt Law LLC has made the tax S Corp tax election, and this may offer tax advantages. We can discuss this in more detail later. So, why is a limited liability so important when we're in healthcare? Let's consider an example. Imagine a patient has an adverse reaction to a treatment you provided. If you're a sole proprietor, you're personally liable for any resulting lawsuit. However, if you operate an LLC, your personal assets are generally protected. And you probably have medical malpractice insurance, which would shield that. You can do that with the sole proprietorship, but after that's depleted, all they have is what's in the LLC. However, remember this: if you, as a healthcare provider, commit malpractice, you're still personally liable regardless of your business structure. The LLC protects you from business liabilities, not your own professional negligence. So, how do you decide which structure is right for your healthcare practice? If you're a sole practitioner with minimal risks and low revenue, sole proprietorship might seem appealing. However, in healthcare, the risk of litigation is significant. If you have employees, enter into contracts with payers, or handle sensitive patient data, an LLC is strongly recommended. It provides a layer of protection that a sole proprietorship simply cannot offer. However, if you're a consultant who is always personally liable for your contracts and you're the only one who does the work, an LLC may not add much value. So consider these factors. One, the risk level. High risk specialties or procedures warrant an LLC or professional entity. Two, liability exposure. If you have employees or handle sensitive data, an LLC is essential. And three, asset protection. An LLC protects your personal assets from business liabilities. Ultimately, the best choice depends on your specific circumstances and your risk tolerance. I recommend consulting with a competent attorney to determine the most suitable structure for your healthcare practice, and it may not be the legal entity choice of an LLC. If you have any further questions, please leave them in the comments below. We're here to help you navigate the legal complexities of the healthcare industry. Also, feel free to visit our healthcare law business website at djholtlaw.com. Thank you for your time.